Hi, today's lesson is on surrogacy. What is surrogacy? Surrogacy is an arrangement in which a woman carries and delivers a child for another couple or person. There are two forms of surrogacy, traditional and gestational. In both situations, the surrogate carries the baby until birth and gives it up to the intended parents. The difference is in how she becomes pregnant. Traditional surrogacy involves artificially inseminating a surrogate mother either with the intended father's sperm. With this method, the child is genetically related to its father and the surrogate mother, or when a surrogate mother is inseminated with a donor sperm. In this case, the child born is genetically related to the sperm donor and the surrogate mother. Gestational surrogacy. In gestational surrogacy, the surrogate becomes pregnant through IVF, in vitro fertilization, where an embryo or embryos created from the eggs and sperm of the intended parents, or donor egg and donor sperm selected by the intended parents, is implanted. The surrogate is not biologically related to the child she carries at all. She is sometimes referred to as the birth mother, but not the biological mother. A surrogacy arrangement means an arrangement, agreement, or understanding between a woman and another person or persons under which a. The woman agrees to become or try to become pregnant with the intention that a child born as a result of the pregnancy is to be treated as the child not of the woman but of the other person or persons, and the woman will relinquish to the other person or persons custody and guardianship of a child born as a result of the pregnancy, and b. the other person or persons agree to become permanently responsible for the custody and guardianship of a child born as a result of the pregnancy. In an altruistic surrogacy arrangement, the surrogate receives no financial reward for her pregnancy or the relinquishment of the child, although usually all expenses related to the pregnancy and birth are paid by the intended parents, such as medical expenses, maternity clothing, and other related expenses. Commercial surrogacy is a form of surrogacy in which a gestational carrier is paid to carry a child to maturity in her womb. The surrogate is compensated for her time and effort, any travel involved, and related medical expenses. The chosen surrogate and the intended parents usually don't know each other before the arrangement. This procedure is legal in several countries, including India, where due to excellent medical infrastructure, high international demand, and ready availability of poor surrogates, it is reaching industry proportions. Commercial surrogacy is sometimes referred to by the emotionally charged and potentially offensive terms wombs for rent, outsourced pregnancies, or baby farms. A potential surrogate mother must be in good overall health and be able to undergo a pregnancy with the minimum amount of risk to her own health. Surrogacy is not something to enter into lightly. Careful consideration must be given to the medical, emotional, legal, and practical issues, and to the implications of surrendering the child at birth. Thought must also be given to the effect on any existing children, the potential surrogate mother's partner, family, and friends. Women who choose to become surrogate mothers in America are typically between the ages of 21 and 42 years old, have previously given birth, and are high school graduates. The majority of surrogate mothers were raised Christian, About 75% are married and approximately 1/3 are employed full-time. Although it's easy to think money is the primary motivation for women who choose to become surrogate mothers, studies have found a variety of reasons impact their decision. Some do choose to become surrogates for financial reasons, while most want to share their own gratification of motherhood with an infertile couple. Countries have taken different legislative approaches to commercial surrogacy arrangements, which combined with a lack of international regulation creates a number of legal problems and conflict of law issues. Several countries, including France, Italy, Germany, China, and Japan, ban surrogacy arrangements altogether, even if no commercial element is present in the agreement. Others, such as the United Kingdom, Australia, New Zealand, Israel, and Holland, allow altruistic surrogacy only. In only a few countries is commercial surrogacy allowed and surrogacy agreements legally enforceable. These countries include India, Ukraine, Russia, and some American states, notably California and Florida, have consequently become destinations for couples seeking a child via surrogacy. The legal aspects of surrogacy in any particular jurisdiction tend to hinge on a few central questions. Are surrogacy agreements enforceable, void, or prohibited? Does it make a difference whether the surrogate mother is paid, commercial, or simply reimbursed for expenses, altruistic? What, if any, difference does it make whether the surrogacy is traditional or gestational? Is there an alternative to post-birth adoption for the recognition of the intended parents as the legal parents either before or after the birth? Although laws differ widely from one jurisdiction to another, some generalizations are possible. The historical legal assumption has been that the woman giving birth to a child is the child's legal mother, and the only way for another woman to be recognized as the mother is through adoption, usually requiring the birth mother's formal abandonment of parental rights. Even in jurisdictions that do not recognize surrogacy arrangements, if the genetic parents and the birth mother proceed without any intervention from the government and have no changes of heart along the way, they will likely be able to achieve the effects of surrogacy by having the surrogate mother give birth and then give the child up for private adoption to the intended parents. If the jurisdiction specifically prohibits surrogacy, however, and finds out about the arrangement, there may be financial and legal consequences for the parties involved. Some jurisdictions specifically prohibit only commercial and not altruistic surrogacy. Even jurisdictions that do not prohibit surrogacy may rule that surrogacy contracts, commercial, altruistic, or both, are void. If the contract is either prohibited or void, then there is no recourse if party to the agreement has a change of heart. If a surrogate changes her mind and decides to keep the child, the intended mother has no claim to the child, even if it is her genetic offspring, and they cannot get back any money they may have paid or reimbursed to the surrogate. If the intended parents change their mind and do not want the child after all, the surrogate cannot get any reimbursement for expenses or any promised payment, and she will be left with legal custody of the child. Jurisdictions that permit surrogacy sometimes offer a way for the intended mother, especially if she is also the genetic mother, to be recognized as the legal mother without going through the process of abandonment and adoption. Often this is via a birth order, in which a court rules on the legal parentage of a child. These orders usually require the consent of all parties involved, sometimes including even the husband of a married gestational surrogate. Most jurisdictions only provide for a post-birth order, often out of an unwillingness to force the surrogate mother to give up parental rights if she changes her mind after the birth. A few jurisdictions do provide the pre-birth orders, generally only in cases when the surrogate mother is not genetically related to the expected child. Some jurisdictions impose other requirements in order to issue birth orders. For example, that the intended parents be heterosexual and married to one another. Jurisdictions that provide for pre-birth orders are also more likely to provide for some kind of enforcement of surrogacy contracts. Ethical issues that have been raised with regard to surrogacy include: to what extent should we be concerned about exploitation, commodification, and/or coercion when women are paid to be pregnant and deliver babies, especially in cases where there are large wealth and power differentials between intended parents and surrogates? To what extent is it right for society to permit women to make contracts about the use of their bodies? To what extent is it a woman's human right to make contracts regarding the use of her body? Is contracting for surrogacy more like contracting for employment labor, or more like contracting for prostitution, or more like contracting for slavery? Which, if any of these kinds of contracts, should be enforceable? Should the state be able to force a woman to carry out specific performance of her contract if that requires her to give birth to an embryo she would like to abort, or to abort an embryo she would like to carry to term? What does motherhood mean? What is the relationship between genetic motherhood, gestational motherhood, and social motherhood? Is it possible to socially or legally conceive of multiple modes of motherhood and/or the recognition of multiple mothers? Should a child born via surrogacy have the right to know the identity of all of the people involved in that child's conception and delivery? Surrogates are generally encouraged by the agency they go through to become emotionally detached from the fetus prior to giving birth. Instead of the popular expectation that surrogates feel traumatized after relinquishment, in an overwhelming majority describe feeling empowered by their surrogacy experience. A 2011 study from the Center for Family Research at the University of Cambridge found that surrogacy does not have a negative impact on the surrogate's own children. A recent study involving 32 surrogacies, 32 egg donation, and 54 natural conceptions families examined the impact of surrogacy on mother-child relationship and children's psychological adjustment at age 7. Researchers found that both surrogacy and egg donation families function well in the early school years. In 1996, the Israeli government legalized gestational surrogacy under the Embryo Carrying Agreements Law. This law made Israel the first country in the world to legalize state-supervised surrogacy. Each instance of surrogacy must be approved by a state-appointed committee. The requirements are strictly governed. Surrogates must be unmarried women, single, widowed, or divorced, who already have at least one child of their own. She cannot be biologically related to either designated parent. The sperm has to belong to the designated father, and the egg must not be that of the surrogate mother. The egg can belong to the designated mother, or, if her ova are not viable, can be donated by an egg donor. The designated parents and the surrogate mother must all share the same religion, so the child's religious status will be clear. This is consistent with the legal philosophy of family law in Israel, in which individuals are accorded rights and status on the basis of their religious and family status. The designated parents must meet age requirements, and the mother has to prove that she is infertile or that pregnancy would significantly damage her health. The law excluded single men or women and same-sex couples. After the birth, The designated parents must submit a request to receive legal parenthood, and under the court's confirmation, they will be the child's sole guardians and his or her parents in every respect. The surrogate mother can only withdraw from the agreement and keep the child before legal parenthood is granted to the designated parents, and only if a social worker appointed by the court attests that the circumstances have changed in a way that justifies the withdrawal and that the child's welfare would not be hurt by the withdrawal. The child is under the tutelage of a social worker representing the state from birth until the completion of the adoption procedure. The agreement is not commercial. The surrogate mother can be compensated for her services and expenses, including legal counseling, health insurance, time, pain, loss of earnings and earning capacity, and any other reasonable expense. The Ministerial Committee for Legislation approved an amendment to the surrogacy law, which would allow same-sex couples and singles to become parents with the aid of surrogate mothers in Israel. In May 2013, Attorney General Yehuda Weinstein announced a game-changing progressive policy shift for how the state addresses homosexual parenthood of a child born through surrogate motherhood. According to the old policy, the man from the homosexual couple, who is the child's biological father, must pass a paternity test in which a sample of his genetic tissue is checked to prove he is the biological father. Subsequently, the second man in the couple, who has no biological relation to the child but is jointly involved in all of the decisions of parenting, must go through a lengthy process to legally adopt the child. Couples have complained that the adoption process for the second man can easily take up to 3 years. Under the new policy, although the biological father still needs to pass a paternity test, upon passing the test, the family courts can immediately issue a special parenthood order. The second man will then be able to become a full-fledged trustee of the child until the adoption process concludes. Effectively, this will grant the two men full parental rights and powers at a much earlier point. The Health Ministry wants to expedite the process of repatriating to Israel infants born abroad through surrogacy. When carried out abroad, surrogacy is usually subject to the law of the land in each country, but agreements between Israel and each country also play a part. In the past, Israel has refused to issue passports to babies born to surrogate mothers in Thailand for Israeli couples because under Thai law, the surrogate mother retains full parental rights. In those cases, the surrogate mother had to sign a statement agreeing to allow the child to be taken to Israel to live with its father. Until now, Israeli couples have been able to use surrogates in other countries without paying the tens of thousands of shekels usually charged by surrogacy agents. According to Health Ministry figures, the number of heterosexual couples seeking surrogacy services and becoming parents through the process rose significantly over the past decade. In 2000, there were 20 applications and 6 births, while in 2011, these numbers rose to 92 and 49 respectively. Surrogacy continues to be a complicated tangle of legal, social, ethical, and technological issues. Arguments against commercial surrogacy compare it to baby buying and selling, a womb for rent. Some detractors also believe that commercial surrogacy uses technology to exploit women, children, and the meaning of motherhood and fatherhood in our society. On the other hand, surrogacy has allowed many childless couples fulfill their dream of raising a family.